securities for money. Shows as an action. Shows as an action being a right to bring a lawsuit. Stocks, bonds, accounts, vouchers, evidence of debt or title, or life insurance policies. Those sorts of things we want for sure in the trust, not being operated under the terms and provisions of your will. One of the things that we mentioned early on in this video, we don't want probate if we can avoid it. If a lot of investments, money, bank accounts, that sort of things are going to be handled by your will, you're gambling on probate. You're gambling on whether or not probate will be necessary in the administration of your estate. So we want those things to be in the trust. And then the next clause, the rest and residue article, is picking up money, securities, investments, and that sort of thing. We hope that they're not outside of your trust, but if they are, if for some mistake or error you have those type of assets outside the trust, this is a fail-safe. This is saying, in essence, I made a mistake. I wanted those things to be in my trust, so the executor picked them up and put them into my trust. And this is why this type of a will is often called a pour-over. You're picking up those assets that I really wanted in my trust anyway, and you're pouring them over into the trust. And it's a specific direction to your executor to take those rest and residue articles and place them into the trust.
The next article that some of you will see and some of you won't is called the guardian article. If you have minor children at the time you're writing your trust, you will see this article here. If you do not have minor children at that time, you will not see this article. For those people who have minor children, the guardian article is designed to name someone if you and your spouse are not there to raise your children. So I want you to take note of this article and make sure that we have spelled the next in line guardian of your children's names correctly and that their address is correct here. We typically advise that you have at least one backup, but you can name more if you want to. So there should be, I'd like to see 2 people named here, a primary, and if they can't or won't do it, a backup to raise your children in the event you and your spouse cannot do it. I think that's it for that article.
The next article that I am going to review with you is called the survival article. But if I can take things a little bit out of order, go back to the personal property article. If you had specific bequests, Melissa will have highlighted those for you so that you can review those. Please make sure that we've covered all the specific bequests that you wanted. And now I'll take you back to the survival article. This is a complementary clause to the simultaneous death clause that we talked about in the trust. And it has to do with ensuring your estate having the best tax advantage. If you and your spouse die simultaneously, where it's impossible to decide who died first, what we want to be sure is the spouse that has the larger estate is to be deemed to have died first. If your estates are basically equal, or you followed our suggestion that you make them equal, then we typically pick the husband as being the one who died first. So make sure this clause in your will, wife, your clause is the complete opposite of the husband's. We don't want these things reading alike. So help us do our proofing here. They should be the exact opposite. So if my spouse and I both die and there is insufficient evidence that we died otherwise than simultaneously, comma, my spouse shall be considered to have survived me, or my spouse shall be considered to have predeceased me for all purposes. You're looking for the opposite in that particular clause. And then the next clause, executor appointment and powers article, this is where you're nominating your executor. And I want you to think through everything that we've covered in this video. We talked about the trust. That trust has a lot going on with it. It's hopefully going to avoid probate, is going to avoid unnecessary taxes, is going to manage the property that you have for you, as well as how you direct in the event of your death or incompetency. So hopefully this executor clause is not necessary for probate. And if you followed our instructions, you're going to be avoiding probate. So what's the executor's job going to be? Basically, to make your final funeral arrangements and deal with making sure the personal property goes the way you want. You may have written a memorandum stating how you want personal property to go. It may be part of the will, it may not be part of the will, but whatever needs to happen, get the family together, get the personal property taken care of, and the job's basically over. We generally recommend, if you're both able, to name each other as executor, and then children or other people that you know you would want to make final funeral arrangements for you, that would do it the way you want. So the only thing Illinois says is 18 years of age or older, so it can be any person regardless of where they reside. So far as the powers are concerned, I want you to know that there is a tax power in those listed so far as your executor is concerned. Again, hopefully we never need that. Basically what it says is my executor can go get the share of tax owed by any beneficiary that I have under my will. So if you're leaving $100,000 to someone and that $100,000 is costing the estate $10,000 in death taxes, you're saying you can give them a net check, hold back 10 so that you have that to pay the taxes on that, and give them what's left. Hopefully that's all taking place in the trust and we don't need it here.
Right.
And then that's paragraph A under the powers, and then the remaining powers are under letter B. And again, hopefully these powers are not necessary. They're very similar to the powers you give your trustee, so that the trustee can carry out the terms and provisions of the administration of your estate as you so dictate.
After the powers, you're going to come, and I'll give you just a second to flip through those. And again, feel free to read through the trust powers and let us know if you have any questions about those. But after the trust powers, you'll see a blank for a date, and we're going to fill in that date.
It's going to be the will powers.
The will power, I'm sorry.
Similar to the trust
Similar
powers.
to the trust powers, right. After you get through those powers, you're going to come to the date section, and we're going to leave that blank for now, but when you come in to sign, we will date it as of the day you come in. Right below that, you're going to see your name and a place for you to sign. I don't want you to sign the drafts, obviously, but I do want you to make sure that we've spelled your name correctly. If you've got a middle initial that you wanted us to use, I want you to make sure it's there, so that we can make sure we have that right. Below that is a place for our witnesses to sign. When you sign this will, Illinois law requires that we have 2 witnesses present. So typically we provide those witnesses for you from our office, but you may also bring in your own witnesses if you want certain people to witness you signing your will. Keep in mind, if you do this, they cannot be related to you, and they cannot be anyone who's going to receive anything under your will. So if you want to do that, let us know in advance and we can talk to you about that, but otherwise we will simply provide the witnesses for you here who will witness your signature on this document. And then the final page is a place for a notary, and again we will provide the notary in addition to the witnesses, and we will notarize your will upon you signing it.
And the advantage of that final clause in having your witnesses' signatures notarized is they don't have to be found at the time of your death. They don't have to testify in order to make your will valid. So it's a little bit more formal when you're signing, but it pays huge dividends for you. We've had cases where it's very difficult to find witnesses. The family doesn't know who they are. So bear with us on the formality. It makes it a little bit easier later.
That's right. And that concludes your will.
Thank you very much.